Hi, welcome back everybody. This is the Now Morning Show here on TTT. We are also live on Talk City 91.1 FM and on Facebook at TTT Live Online. As I mentioned earlier, we have with us Martin George, who is an attorney, and we're going to talk about that Privy Council ruling on Monday. What does it mean for Trinidad and Tobago? How does it affect us? Because the government, through the Attorney General, is saying that that ruling really has no significance. It's a run-of-the-mill ruling, and the opposition is saying it's a major landmark ruling here for Trinidad and Tobago. Mr. George, good morning and welcome.
Good morning to you, Rishi, and good morning to your team, and good morning, Trinidad and Tobago.
So, what is this ruling all about, first of all?
Well, the essence of it is basically the Privy Council has indicated that, look, there ought to be access to primarily the two witness statements, which would have been the basis and genesis of the volte-face by the learned QC who was advising at the time as to the pursuit of the Petrotrin matters. So that would have been Mr. Vincent Nelson. Of course, that now adds that dimension to the entire scenario. Because previously, the advice he had given was in favor of prosecuting the matters, and then upon having sight of these two witness statements, he then revised his opinion and he said, listen, this is information I did not have before. Had I seen this information, my views may have been different. And therefore, in the circumstances, what he said is that it may be that a judge might consider that what transpired at Petrotrin was the result of bad decision making as opposed to negligence. Because you see, there's a difference. Because one may make a bad business decision. So, in other words, either through lack of information, or maybe you thought it might have worked out, or you were taking a risk, because business does involve risk. Yep. Right? So there's a difference between a bad business decision and actual negligence in the running and management of a company. And the threshold is fairly high when it comes to holding someone, particularly in relation to a state corporation, guilty of that level of negligence. It's not impossible, but I think what he felt is that having had sight of those two witness statements, he felt that, look, in light of that, it would be difficult to say, look, this is a case that I am convinced about, and that's why he made the about face in relation to the matter.
Yeah, this matter went to the High Court here in Trinidad and Tobago, and then to the Court of Appeal, and then it was taken to the Privy Council. Now, what was significant for many people is that the Privy Council's ruling was completely opposite to what was ruled here in Trinidad and Tobago. What does that mean, if anything?
Well, the point is, that's why we have your final Court of Appeal. And, I must just say, Rishi, we must bear in mind, the only reason why the Privy Council is never wrong is because there's no court above it. If you understand me, because the point is, you have a ruling at the High Court, somebody disagrees with it, they go to the Court of Appeal, the Court of Appeal may say, look, the High Court judge was wrong, look, just yesterday we had a decision by Justices of Appeal, Jamada and Smith, where they ruled in relation to this issue with the Marcia Air Caesar, and they actually made orders that the Chief Justice and other persons are to be cross-examined on their affidavits. So that's going to be an interesting scenario coming up. But the point is, then from the Court of Appeal, you may have a decision, and the Privy Council may rule one way and say, look, the Court of Appeal was wrong. The Privy Council has done that several times in the course of our jurisprudence, and that's how the law grows and develops. So there's nothing wrong with a superior court analyzing and saying, look, we think that this was an error of law, we think that this was a mistake. But at the end of the day, in law, there are so many subtle nuances of expression, and, you could analyze one phrase, for an entire day as to what it meant or what you understood it to mean, what I thought I said, so there's always that dynamic at play. And, I'll just give you one nice example. There are two cases, the Wagon Mound and Repalimis. Okay, so, students of law can look them up. Those are two cases that are so interesting because the Privy Council, on the very same day, ruled one way in the Wagon Mound and then later ruled the opposite way in Repalimis. And there were two very similar subject matters, fairly similar fact scenarios. So the point is the Privy Council itself, if you understand me, is not always consistent with its rulings, but the point is it's our highest court of appeal and we have to respect the decisions of it. And it just brings one other thing into play. I think that, we have to now wonder, and you ask yourself, in terms of the CCG, had this been a decision of the CCJ, how would citizens have treated with it? Would they have respected it the same way they automatically accept the Privy Council ruling? And that's one of the concerns I have in relation to the CCJ as our final court of appeal. Yeah. Have we reached that level of maturity as citizens where we accept it and we don't then try to dissect the judgment to say, well, look, how many Afro-Trinbagonians on the court, how many Indo-Trinbagonians, or this one knows the prime minister, or that one plays golf with the president, you know, that kind of thing. So, you know, we have not appeared to have reached that level of maturity as a nation whereby we would accept unquestioningly decisions from the CCJ had they been handed down, especially in a scenario such as this, where the Privy Council says, that's right, exactly, because the Privy Council said, look, it looks like politics was at play. And, you know, the corollary to this, and it's an interesting scenario, because when you look at it, okay, so at this point of the discontinuance, the Privy Council is clearly of the view that politics was at play there. But then you ask yourself, in terms of the genesis, the instigation of the matters ab initio, was there politics at play also? You know, so it's an interesting dynamic. And I think our politicians need to, you know, get over themselves and let's look at the substance of the matters. Because if they keep going on with this blame game and finger pointing, it ends up in a circular firing squad.
Do you think that it was just a run-of-the-mill decision, or it has some major significance in Trinidad and Tobago?
Well, the thing is, I think what I understand from what the Attorney General said when he said it was run-of-the-mill, in that the Privy Council has made decisions like this, ordering the production of documents, ordering that matters proceed, which may have been previously stopped. So yes, in that sense, you can look at it that way. But it's important in the sense that, given the fact that these were documents which the state had previously failed and or refused to disclose, and the Privy Council has ordered that, hey, look, they ought to be disclosed. Now, the Attorney General, to his credit, has said that he has no fear and no worry about disclosing them, and he's willing and happy to disclose them. Now, I mean, if that had been the position from the start, maybe we wouldn't have had to get this Privy Council decision. But the point is, now that we have the ruling, the order is that they must be disclosed.
All right, well, thank you very much, Mr. Martin George, for coming on, chatting with us and sharing your expertise in this matter. We have to take a break and come back with more.